Good afternoon and welcome. Program today we are looking at the big contempt of court debate. The big contempt of court debate has been triggered after consent has been provided for yet another person to face contempt charges. This time we are talking about cartoonist Rachita Taneja. This development took place after Taneja did a couple of tweets on the bail, the granting of bail to Republic TV editor-in-chief Arnab Goswami. Rachita becomes the second person to face these kind of charges after cartoonist Kunal Kamra. Now, to talk about the wider debate around contempt of court, we are joined now by one of India's best-known activists who has himself paid a 1 rupee fine after being convicted for contempt of court, but also refused at that point to apologize in the same way that Kunal Kamra has taken a similar position. But there are larger questions that arise around this law, including the fundamental question, is it an archaic law from the 1920s that needs to go? What is that thin line that separates dissent from abject humiliation of a very important institution like our courts? So welcome to the program. Welcome to Mojo, Prashant Bhushan. Let me start by asking you how you look at these developments. We've got now Rachita Taneja, a cartoonist, becoming the second after Kunal Kamra to face this kind of consent from the Attorney General, who believes that both of them should be tried for contempt. Now, you may or may not agree with the tone and tenor of either Kunal Kamra's tweets or Rachita Taneja's cartoons as shared on Twitter, but how do you see this development?
You see, I have always held that irrespective of whether one agrees with the tone and tenor of what somebody is saying about the Supreme Court or any of its judges, unless the speech or the action interferes with the administration of justice itself or interferes with court proceedings, it should not be treated to be contempt, criminal contempt. Because criminal contempt is in two parts. One is interference with the administration of justice or with the court proceedings. And second is scandalizing the court or lowering the authority of the court. I have always felt that this scandalizing or lowering the authority of the court, this is a colonial relic. This is from a time when courts were regarded as the agents of the king. And therefore, because the king nobody could comment adversely against the king, therefore any adverse comment against judges was regarded as scandalizing or lowering the authority of the court. This has been abolished in England. It's not there in the US. In the US, the test is clear and present danger to the administration of justice. The reason why this is a dangerous jurisdiction is because, firstly, the respect or authority of the court does not depend on what people say about it. It depends upon the court's own actions and how those actions are perceived by the people. If you try to shut the mouths of people who are saying something adverse about the court, that brings the court into greater contempt and ridicule. This has been the public experience everywhere in the world. Therefore, the view that you can increase the respect for the court by shutting the mouths of those who are criticizing the court or even those who are abusing the court, that's a totally mistaken notion. Secondly, this is a jurisdiction in which judges sit as judges in their own cause. And if the contempt is in the Supreme Court, if the permission has been sought for the court and the Supreme Court initiates contempt proceedings, not only are they sitting as judges in their own cause, but there is no appeal against their judgment. The Supreme Court itself has said in several cases that at least one appeal against a criminal conviction should be there, but there is no appeal against this. So therefore, in my view, this is mistaken, it is counterproductive, and it is bound to bring the court into greater contempt and ridicule.
But let me ask you this. We have KK Venugopal's statements on this particular set of illustrations with regard to Arnab Goswami's bail. And it's kind of a follow-up to what Kunal Kamra did. These are young people. There's also a generational shift. People of my age were trained to take institutions somewhat more seriously. The age of social media has made it possible. You can argue whether it's healthy or not healthy to actually sit behind a table and pass a comment on anybody. So we had Kunal Kamra, for example, the stand-up comic, making direct insinuations about Justice Chandrachud personally. You now have KK Venugopal talking about how, what has happened in Rachita Taneja's illustrations are an assault on the respect that the Supreme Court is expected to command. Do you think that there is any merit in Venugopal's concerns? Because the same Venugopal 3 days ago declined to initiate contempt proceedings against you all over again. The same Venugopal has in the past rejected a contempt complaint against the actor Swara Bhaskar, who is not known to be a fan of this government. So how do you read Mr. Venugopal determining some cases fit for contempt and rejecting others?
No, one can make a distinction between those which are utterly abusive and those which are just an expression of opinion. One can even make a distinction between those which accuse the court of being guided by extraneous considerations or being guided by corrupt considerations, and those which merely very strongly criticize the court. One can make that distinction, but I am saying something else. Let's assume that somebody says something which is abusive, or let's say accusing the Supreme Court of being guided by extraneous considerations. I mean, for example, the cartoons here or the tweets here are accusing the Supreme Court of having become captive to the ruling government or having surrendered to the ruling government, etc.
Yeah.
Now, in my view, that's firstly a matter of opinion. Whether the court has surrendered to the ruling government or not. For example, when the Daily Mirror published the photographs of Supreme Court judges in UK upside down saying, "You fools," one judge is supposed to have remarked that, "Look, you old fools." He said, "Old we are, fools is a matter of opinion." So now, these are matters of opinion. Even if the comment is very abusive, or let's say it is defamatory, the judges concerned or even the court can take action for defamation. But contempt is actually firstly not justified because you are acting as a judge in your own cause. Criminal contempt for this kind of even abusive remark. And secondly, it is counterproductive. You see, when people get the impression that the court is using its authority to silence criticism, what many people feel may be a legitimate criticism, what many people may even feel is a legitimate abuse. So you see, what happens is that it ends up becoming counterproductive. The contempt proceedings against me, far from silencing criticism of the court, in fact, invited far more criticism of the court. Far from making people fearful of the threat of contempt, it made people more outspoken and made people lose the fear of contempt.
But let me ask you this: has social media changed the rules of the game? Because for example, the question that we are getting on our live stream is that every day, there is a trolling that takes place by the right, by the left. Naveen Kumar says, "What about trolls who insistently tarnish the image of individuals in a digital age? Should the court have some new tolerance in these times for both criticism and abuse?" I think this is a fundamental question. Technology has now changed what can be said about anybody. Now, I don't necessarily think that's a great thing. I think there are laws of defamation. Not everybody has a thick skin. There are people who have, softer beings. Many of them are pushed out of social media platforms. So, how far can criticism go before it becomes abuse, especially when it comes to judges of the Supreme Court?
No, in my view, judges of the Supreme Court should be, in my view, treated as just any other citizens. So therefore, if they are abused or if they are defamed, then of course, both civil and criminal defamation is open to them. And they should resort to civil and criminal defamation, etc. But suppose somebody is saying, let us say, that this court has surrendered to the government. It has become,
Yeah.
as somebody has said, that it has become a Sanghi court, uh,
Mm.
essentially saying that it is greatly influenced by the BJP and the RSS, etc. Now, that's a matter of opinion. If you say that, look, that's defamatory, etc., the person can say, look, this is a public institution and this is a matter of my opinion. Why
But
should you say?
suppose somebody calls you Prashant Bhushan corrupt, right? और ये मतलब
Yeah,
ट्विटर पे
yeah.
तो कुछ भी कहा जा सकता है. So someone says Prashant Bhushan is compromised. He takes money from Naxals. I'm actually picking up something that the right wing could say about you, right?
No,
Are you going to
they
look
do.
the other way?
They,
Are you going to look the other way? Would you ignore
some
it?
of some of them may be saying the same thing also, which you just mentioned. Now, if I feel that it's serious enough, I will take action for defamation, uh, maybe civil defamation. I feel that criminal defamation is also a law which has outlived its utility. It is, in fact, being used more to silence criticism, etc., of people and legitimate comment because the process is the punishment very often. But
Yeah.
civil defamation certainly should be there and people should resort to it. If somebody is defamed, and defamation has a technical meaning, what defamation means, then certainly. But if one is expressing, I mean, even in defamation, there are valid defenses, which is if you say something, if you express an opinion about a public person or a public institution, that's not defamation. But if you accuse somebody of doing something which is false, I mean, if you make a false accusation against somebody that he has done something which is generally regarded as very bad, then certainly he would be open to defamation and action for defamation should be taken.
As someone who has in fact been convicted in a contempt of court case, paid a ₹1 fine, and then refused to apologize, what do you personally believe about both Kunal Kamra's comments on Justice Chandrachud in the Arnab Goswami Bail case, and now the illustrator cartoonist Rachita Taneja? What did you feel about both what Kunal Kamra originally said and the position he has taken since then, and now this second contempt case against Rachita Taneja?
You see, I do not wish to comment about exactly what they said and what I feel about that, etc. I do feel that I would not have said the same things in the same way or in a similar way myself. I feel that some of those comments are in bad taste. But having said that, I still do not think that it is either correct nor advisable to take contempt action against them. It could, at best or at worst, amount to defamation, and maybe defamation action could be taken against him.
So you're saying you would not have used the language that Kunal Kamra did, but you still do not support contempt proceedings against him.
Yes, yes, that's my position.
And but can judges actually file for defamation? How does that work?
Yes, yes, of course, judges can file for defamation. Anybody can file for defamation. Even the Supreme Court as an institution can also file for defamation. Just as a company can file for defamation of the company, the Supreme Court as an institution can also file for defamation. But of course, then all the defenses of truth as well as justifiable comment, etc., would be open to the person who's accused.
Let me ask you like this specifically. Do you believe the Supreme Court is entitled to protections that are separate or distinct from what citizens like you and me are entitled to when it comes to what sort of language can be used against us, what kind of motives can be attributed to us? Does the Supreme Court merit or need any special protection?
No, I don't think it needs any special protection except to the extent that if there is any action or even speech which interferes with the administration of justice, then yes, that should be actionable. Just as there is civil contempt for disobeying a court's order, similarly, criminal contempt should be restricted to interference in the administration of justice. For example, somebody threatens a judge that, look, if you decide this way, I will break your leg, or somebody threatens a witness or a lawyer, that's interference with the administration of justice. Similarly, if somebody jumps on the table of a judge or creates such rowdy behavior that he doesn't allow court proceedings to proceed, that is also interference with the administration of justice. So those should be actionable, but not mere comment or even abuse of a judge or even the institution. For that, defamation proceedings, in my view, should be sufficient.
Now, we've spoken about this earlier, but I do want to bring it up again because, in your context, this case comes up again and again, the Justice Karnan case, and people ask again and again, why did Prashant Bhushan at that time welcome or the contempt proceedings against his judge? Now, for those of our viewers who do not know about this case, Justice Karnan had written a letter to the Prime Minister, basically alleging that 20 judges were corrupt. That letter never made it into the public domain. The media was also barred from reporting on that case, and Justice Karnan eventually actually went to jail. Now, do you look back and believe that you made a mistake in taking the position that you did? There's commentary I've seen which says that Justice Karnan was not from the privileged sort of elite of Delhi. He was not known. Some people have alleged caste discrimination. There are all kinds of things that come up when we talk about the Justice Karnan case. How do you look back at that in the light of how commonly now contempt proceedings are being used against individuals?
Justice Karnan did not merely abuse and accuse judges of being corrupt, etc., caste is corrupt, which was unfair, but he also proceeded to abuse his judicial office by issuing purported judicial orders to arrest those Supreme Court judges and be brought before him. That, to my mind, is interference with the administration of justice. That's not merely unfair accusation against a judge. It is abuse of his position and his authority as a High Court judge, and it is interference with the administration of justice. So that stands on a different footing. However, having said that, you see, it seems that Justice Karnan became kind of partially, emotionally and mentally destabilized at that time, and he was doing things which he probably didn't even understand as to what he was doing. And at one point of time, the Supreme Court did suggest that he should be sent to a mental asylum or some for psychiatric treatment, etc. But he was not agreeable for that. But you see, his case stands on a different footing. It's not at par.
The reason I bring it up is because many people are saying that this is an archaic law that needs to actually go off the statutes. We've had it since 1926. You've had some context in which you have referenced contempt of court. Karnan was one. I think Nageshwar Rao, the CBI, is another example that people throw in your face. But with everything considered, do you believe this law needs to go now? It shouldn't even exist, because you can't both say that the Supreme Court doesn't deserve any special protections but still want contempt of court to be in place.
No, the contempt law is required for two reasons. One, there is civil contempt, which is disobedience of a court's order. There needs to be a sanction against disobedience of court's orders. So that civil contempt should remain. Secondly, criminal contempt also should remain, so far as actual interference with the administration of justice is concerned. That should certainly be actionable and punishable as contempt. It's also so in both the UK as well as USA, which have similar kind of judicial system, where in USA, any clear and present danger to the administration of justice is contempt. So therefore, if you threaten a judge, if you don't allow court proceedings to go on, that should certainly be actionable.
You've also been quite critical on this platform and others on how the Supreme Court processed the Arnab Goswami bail proceeding, and for that you have been accused of applying liberal principles selectively by many on the right wing. Kunal Kamra and Rachita Taneja are now facing contempt proceedings. Both made comments on the same case that you've made a comment on. You chose a different set of sort of words to make that point. Are you not worried, Mr. Bhushan, that as you question the autonomy of the Supreme Court, that you could face another contempt complaint, and maybe this time the Attorney General would not be so sort of calm in saying, no, Mr. Bhushan, we will not proceed against contempt? I mean, are you not concerned? What is that line that you draw for yourself beyond which you would not go, but below which you continue to criticize the court?
The line that I draw for myself is that I make my comments on what I feel the court is doing or not doing, whether it's right or wrong, whether the court has kind of surrendered to the government. Those kind of comments I do make quite freely, because I feel that as a citizen of this country and as a lawyer who has been keenly observing the court, I am entitled to make those comments in public interest, also for self-correction of the court. So far as making an accusation, a factual accusation against a particular judge of doing something which is regarded as very bad or unconscionable, for example, taking a bribe or sexual harassment of somebody, etc., is concerned, I do that only if I have concrete evidence of that. If I have concrete and very clear evidence of that, then I make that accusation. And then truth is a defense. I'm not worried about Attorney General giving permission against me or not giving permission against me, or whether the court wants to restart fresh contempt proceedings against me or not. I feel that whatever is my duty as a public citizen, especially at a time when I'm seeing democracy being hedged in and hammered from all sides, and the court's independence having collapsed, then I feel that it is my duty as a public person and as a concerned citizen and lawyer to raise these concerns publicly.
You just made that big statement again. You said the court's independence has collapsed. So is that a statement that you make with responsibility, knowing that tomorrow somebody could file a case saying that you just made a very broad, generalized statement against the Supreme Court? There must be judges who you think are exceptional. You know, there's always judges that people think are more independent-minded than others, and this goes on in every court, in every country of the world, right? When you say the court's independence has collapsed, do you mean the Supreme Court downwards? Do you mean particularly the Supreme Court? And what is your basis to make a statement? Because you're basically implying that the court, in your allegation, that the court is politically compromised.
Well, I have said this many times. I said this in my earlier tweets. I have said it in a recent interview in the Hindu, which was published last Sunday. When I mean the Supreme Court, I mean the court generally. I don't mean all judges. I don't mean to say that no judge in the Supreme Court is independent. There are, of course, honorable exceptions. But on the whole, if you see the role of the Supreme Court over the last 4 or 5 years, it is very clear, and there have been innumerable articles by very, very serious and senior judicial commentators, including retired judges, who have said exactly the same thing. And I have said in my interview to the Hindu as to why I believe this has happened. I mean, one of the reasons is that if the Chief Justice's independence comes under question, then the Chief Justice, being the master of roster, can control virtually the outcome of every politically sensitive or important case, because he decides which court to send which case to. And there are always judges in the Supreme Court who are known to be kind of either ideologically inclined or politically inclined, or weak and not independent enough to be able to take any bold decision against the government. So therefore, you can always decide the outcome, and that is precisely what those 4 judges said in their press conference in January 2018, they said that the Chief Justice is misusing his powers as master of roster to assign politically sensitive cases to preferred benches in order to achieve a particular outcome which is palatable to the executive, and therefore democracy is in danger. This is precisely what they said.
So let me ask you in the end, we have a couple of minutes left. You overall do believe that the Supreme Court's independence, I'm quoting you verbatim, has collapsed?
Yes, to a very large extent, that is true. And that is not merely my view, it's the view of a very large number. I can point out at least 20 articles written by very serious commentators, very senior and serious commentators, including retired judges, who have said the same thing.
In that context, what do citizens do? Because if they criticize, and let's say they take the criticism too far, for example, as you believe Kunal Kamra or the cartoonist Rachita Taneja may have done, should the court, like what do you think Justice Chandrachud, you've known him, how do you think Justice Chandrachud should respond to Kunal Kamra's comments about it?
No, I don't think Kunal Kamra's comments were particularly aimed at Justice Chandrachud.
I mean, he named Justice Chandrachud in his tweets, so that's why I'm bringing
it. He just said that, that he gave unusual grace to Arnab Goswami. Now, that's a comment that anybody can make. It was unusual for sure, because the case was heard in 15 hours with as many as 10 objections from the registry not having been cleared. The case was heard during vacations of the Supreme Court. The case was heard despite his parallel proceedings for bail in the Sessions Court were pending. The case was heard for a whole day and immediately interim relief was given. This hardly ever happens. This has hardly ever happened in the Supreme Court before. Certainly never in a case like this. So therefore, it was certainly very, very unusual. And therefore, people are entitled to make a comment on the unusual nature and the alacrity with which the Supreme Court gave relief to a person who is commonly perceived as an acolyte of the government, or as a broadcast of the government, or as a big mouth of the government. So therefore, that's a comment which anybody could make. And Justice Chandrachud ought to have just shrugged it off, as people should do, by saying that our shoulders are broad enough. In any case, it's not Justice Chandrachud who has initiated contempt proceedings. It's the Attorney General who has given permission. And I believe that if it was left to Justice Chandrachud, he would shrug it off. He would say our shoulders are broad enough.
And you believe that's what he should do when the case finally goes to the Supreme Court. Of course, it will probably not go to him. But you believe that when Kunal Kamra's case is tried, Justice Chandrachud could suo moto actually just say that I don't want this, I don't have any, I may have a problem with it, but I'm willing to ignore it.
No, Kunal Kamra's tweet is not merely about Justice Chandrachud. That's only one of his tweets in which Justice Chandrachud is mentioned. He had several other tweets about the Supreme Court in general, and several photographs or cartoons, etc. That's what will be. So therefore, whether Justice Chandrachud says that I'm not interested or not interested will not be relevant for the contempt proceedings against Kunal Kamra.
But you still believe that the court would be better advised in using the option of defamation instead of contempt when it comes to both the Kunal Kamra and the Rachita Taneja cases?
Yes, I believe so.
Okay, we're out of time. My last question to you is this. Given your own experience of being convicted for contempt, paying that ₹1 fine, refusing to apologize, how do you plan to handle the criticism of the Supreme Court going forward? You have in the Hindu and here today questioned its independence. There are any number of people who believe that you speak from a place of not liking the government, just like you accuse the court of being, or some parts of the court of being, too soft on the government. How do you respond to the charge that you see everything through your own ideological prism?
Everybody sees everything from his own ideological or other perspective. Obviously, that would be the case for everybody. So therefore, that's not something that anybody can help. I mean, obviously, and I do try and see it as objectively, as independently as I can. But obviously, my view would be colored by my own ideological perspective or my own understanding of what is right, what is wrong, what is good for our democracy, what is good for the judiciary or not. Obviously, it will be colored by that.
And if you were a lawyer helping Kunal Kamra or Rachita Taneja, your advice to them would be at this point?
No, that depends upon them. You see, they have to be prepared to go to jail, as I had also got myself mentally prepared. That all right, worst comes to worst, they will send me to jail for 6 months. So I was prepared, mentally prepared for that. And once somebody is mentally prepared for that, then he can fight it out or not fight it out or say, all right, do what you want to do.
Does that experience make you today more cautious, more reflective, or has it left you unchanged? Your own conviction in the contempt case?
No, it has left me unchanged. I don't believe that I committed any contempt. And I also believe that not many judges would have held that to be contempt. But unfortunately, there are judges and judges. And there was one particular judge who was used by all chief justices. First, in the Birla Sahara case, where Justice Kher had that matter, and when he became chief justice, he transferred it to Justice Arun Mishra. Then in that Justice Deepak Mishra's medical college case, when that case, Justice Deepak Mishra also sat, as well as Justice Arun Mishra. Then in the sexual harassment case of Justice Gogoi, where again Justice Arun Mishra's bench was constituted, or Justice Gogoi sat along with Justice Arun Mishra, and thereafter it was handed over to Arun Mishra's bench, and thereafter also in my contempt case. But there are not many judges of that kind. I mean, he was in a class by himself, Justice Arun Mishra.
And you're naming a judge again with a full sense of responsibility and cognizant of the repercussions that may come your way.
Yes, of course. I mean, again, there have been at least 20 articles written about him and his legacy. And there was even a retired High Court judge who said, as Oliver Cromwell said to Parliament, we have had enough of you. In the name of God, go. That's what that retired High Court judge wrote in an Indian Express op-ed.
Okay, as they say, we do live in interesting times. I think never before has personal liberty, which actually Justice Chandrachud spoke of at length in this particular Arnab Goswami Bail case, been so ferociously under the scanner, with many people worried that it is being applied selectively to individuals and it must be applied uniformly. Prashant Bhushan, thank you. It's been a pleasure talking to you. Thank you very much, and we'll see you soon again. Thank you, and thank you to our viewers as well. Thank you, and bye-bye.